Good afternoon, everyone. Welcome to the House Standing Committee on Judiciary. Madam Secretary, please call the roll.
Representative Blanton.
Present.
Representative Bratcher.
Here in the room.
Representative Cantrell. Here. Representative Decker.
Here.
Representative Elliott.
I'm here.
Representative Fisher.
Here.
Representative Heverin. Representative Colcarney.
Present in my annex office.
Thank you. Representative Lewis.
Present in the room.
Representative Maddox.
Present.
Representative McCoy.
Here.
Representative Minter.
Here.
Representative Mosier.
I'm here.
Representative Nemus.
Here.
Representative Petrie.
Present remotely from my annex office.
Thank you. Representative Scott.
Present.
Representative Stevenson. Representative Banta.
Present.
Chairman Massey.
Here in the room. Welcome, everybody. As usual, we'll begin with our instructions. No signage in the room. I don't see any, so that's not a problem. Always act in this committee with civility. Should act that way in every committee, but please act with civility. Next, the phones, if they're silented, or if they're on silent, that will help. Make sure when you speak at the presentation table that the green light is on and that you are close enough to the microphone for it to pick you up. We do have a full-packed agenda today, but it should move fairly quickly. I'm going to start off by calling House Resolution 45, and that is my resolution, and so I'm just going to do it from here. And what that resolution is a reference to the search warrant task force that met throughout the interim of the last year. Attorney General Cameron obviously pulled that together. There were several folks as part of that task force. It did not come out with any specific. We have some people in the room that were part of that task force, and I'll ask them if they would like to say anything. But we had some recommendations about how we might be better going forward. It's more complicated than people might think. We had law enforcement, we had defense attorneys, we had government officials, we had prosecutors. I know that many of you are familiar with Commonwealth Attorney Rob Sanders. He was part of that. The DPA was part of that. And so we worked through various groups and tried to come up with some recommendations. And you've been provided those recommendations that are in your packet. Or if they're not in your packet, we will provide them to you. It basically did not come out with any rules directing that something had to be done, but it was a recommendation to the parties involved of what we need to do. One of the things that they discussed quite a bit was the use of e-warrants and making that more profound throughout the state. Part of the issue with e-warrants is some areas don't have good broadband or signal strength. And so we've had to look at those things as well. But we have that here in front of you. It is a resolution that just basically asks for the search warrant task force to be recognized, for the recommendations to be recognized, and to proceed with the discussions of the things that were discussed. I will ask if any of the people that served on the task force that are present, if they would like to make any comments. Would you like to make any comments? Okay. Representative Nemus.
Thank you. I hate to do this, and maybe this is my dereliction in preparation, but we're asked to give our imprimatur to those findings, and I trust the people that were on it, but I haven't reviewed them. I would like to hear from Damon or somebody who was on them. Just 40,000 square foot view. Were there any objections to them by any groups that served?
As he's getting ready to answer, I will tell you, Representative Nemus, that the only way that this came about at the end was that all members of the committee had a consensus as to what was put forward in these recommendations. So anything that was of any concern was stricken, and it was all a consensus-based recommendation.
Thank you, Mr. Chairman.
I'll quickly be responsive. Damon Preston with Department of Public Advocacy. As the chair said, we did wind up at consensus and recommendations. I will say consensus was a step back from unanimous. They were not unanimous recommendations. Some of them were, but not all of them were. I won't go through all the recommendations. The chair said that they would be provided. There were some objections. The objections were from all over the room. Defense would object to some, law enforcement would object to others. So perhaps that's a sign of a working process. But many of the recommendations were just for information because one of the things that frustrated the search warrant task force was the lack of statewide information. And so it's to get more information moving forward so that perhaps recommendations more specific could come to you all down in the future. But right now, we didn't have adequate information. I'll say from the defense, just solely speaking as a single member of the task force, I did not feel that the recommendations went far enough. But my hope is that later on there'll be some follow-up that goes farther than these recommendations. But I am in support of this resolution to adopt and approve of the recommendations.
Representative Elliott.
Thank you, Mr. Chairman. Thank you, Damon Preston, for your testimony. When we talk about the parties that are involved, urging the parties to adopt these recommendations, are we talking mainly about law enforcement agencies?
Actually, the parties involved were the Commonwealth Attorney's Office, the Attorney General's Office, the defense attorneys, judges, law enforcement was involved. What might be helpful to this committee is to go over quickly. There's like 8 recommendations, and I can go through those quickly. I won't belabor them. But one of them was data record keeping because there was insufficient data, as has already been indicated, to affect some of these things. So one of the things that they want to encourage folks to do is to keep adequate records so that these can properly be monitored. But the first recommendation was, as soon as feasible, all state and local agencies with the authority to execute search warrants should utilize an electronic platform maintained by the administrative office of the courts. That was the first one. The second recommendation was that agencies serving search warrants should track the locations at which the warrants were served. Locations should be regularly published in a manner that is accessible to the public. The format should allow the public to compare the number of search warrants served across various zip codes and regions of the Commonwealth. And that format should not reveal the addresses for which the search warrants were served, sought, or obtained. The next recommendation is, in the absence of an emergency, a prosecutor should review and approve a proposed search warrant before the investigating agency seeks judicial authorization. That's because, obviously, when you have different law enforcement agencies, you might have different policies or formats they follow. But if you bring them under the auspices of a Commonwealth attorney that's schooled in this matter, they will be able to check those recommendations. Recommendation number 4 is law enforcement officers should receive search warrant-related training at the beginning of their careers, and thereafter should receive updated training regularly as determined by the Kentucky Department of Criminal Justice Training. And the curriculum should include search warrant form and mandatory components describing the property to be searched, developing and articulating probable cause, time limitations for probable cause, and execution of warrants. Recommendation 5 is all law enforcement bodies should adopt, enforce, and regularly update written policies and procedures that govern the servants of search warrants in their jurisdictions. Recommendation 6, for every search warrant that is sought, law enforcement officers should consider, along with other relevant factors, the time of day that is most appropriate for service. Recommendation 7, whenever the services of a search warrant may impact a minor, Child Protective Services should be notified of that search warrant. And recommendation 8, law enforcement bodies in the Commonwealth should adopt some of a toolkit guide of serving for search warrants. For a list of the items to be included in a toolkit, the Search Warrant Task Force proposes that law enforcement bodies adopt some version of the model toolkit found on page 10 of the report. That basically was the recommendations. So as you can see, it wasn't in any form or fashion a mandate. The parties did commit to continue working on this together. Obviously, when you put prosecutors and defense attorneys and law enforcement and judges in a room, you're probably never going to get a full unanimous outcome. Obviously, in different parts of the state, it's different for rural communities than it is for urban communities. And so we were working through all of those processes. That's why these are recommendations, not mandates. One of the big components underlying all of this is the keeping of data so that we can actually see what is in the best interest of all involved. I
would move adoption.
Okay. We have a motion for adoption by Representative Elliott, second by Representative Mosier. And I will make sure through our staff that we send this whole resolution out to everyone. Again, it's all recommendations, no mandates. I would encourage you to talk to the people that were on the committee too, because we are not going to be a task force that's regularly meeting, but we will be continuing the work that we started. So with that, we have a motion for adoption and a second. This is permitted by a voice vote. So all in favor signify by saying aye. Aye. Opposed? And there's none. So House Resolution 45 is adopted. Next, we are going to have House Bill 185. If the speaker is still here. And Representative Heverin, if you bring your guest forward.
While they're walking up there, I'll make a motion on the committee sub.
We have a motion on the sub by Representative Nemus. We have a second by Representative McCoy. All in favor signify by saying aye. Aye. Opposed? There is none. All right. I'm not sure who's going to go first, but I always like to go with the chain of command. So, Representative Osborne, you have the floor.
Actually, I appreciate that, Mr. Chairman, but I'm going to defer to the actual primary bill sponsor to start us off.
Thank you very much. I'm going to kind of explain why we're in this situation, and I'm going to let Zoe Fairfield speak and kind of tee up the conversation. So House Bill 185, this bill was actually rolled into another DUI bill. I believe it was House Bill 154. What the original bill did was it gave our law enforcement and judges the opportunity to take away license plates whenever someone had a DUI. This was a request from my district judge in Hardin County, and so that was all kind of rolled into one. So we had this bill sitting here, and after the filing deadline, Zoe Fairfield and her dad came to the speaker and a few of us that had been working on DUI legislation and asked if we'd be interested in carrying this bill, and so that's why we have the House Committee sub. And so if there are no questions on that, I'm going to give it to Zoe Fairfield to kind of explain why we're here today.
Hello, everyone. My name is Zoe Fairfield. I'm from LaGrange. I'm thankful for this opportunity to join this committee today to remember my sister Lily, who passed away in a DUI accident in November. I hope to honor her life by making Kentucky's roadways safer for everyone. Today, this body has an opportunity to do just that. House Bill 185 is the proper step forward to ensure no other families face what mine has. This bill will mandate a 48-hour hold for all first DUI offenses. My sister was killed by a driver who had been arrested for DUI just 3 days prior. She was released without any bond and never saw a judge. That driver's extensive criminal history was ignored, and then 3 days later, my sister was killed on her way to school, and I was seriously injured. We cannot continue our current process of ignoring DUI crimes or pretending that they are not violent offenses and that they should be punished as such. Although I believe there is still much to be done with regards to making our roads safer, I hope that this is the process that starts safer roadways and safer laws for all that. Thank you for the committee for hearing this important legislation, and also to Speaker Osborne and Representative Heverin for sponsoring House Bill 185 and your urgency to act.
Thank you, Zoe. So what this bill does is make some changes to the penalty structure to do our part to prevent such a tragedy from happening again. So this would be called Lily's Law in honoring Zoe's sister Lily. To be considered driving under the influence, a person must have a blood or breath test showing a BAC of more than 0.08. Here, the drunk driver was released within hours, and it is scientifically impossible to know how long any given person needs to process the alcohol in their system to be sober enough to drive. Factors include body weight, metabolism, composition, and history of alcohol use play a huge role. Therefore, we cannot legislate the time based on the person, so we must make some general changes to the portion of the penalty structure involving incarceration time after the arrest. So the bill does two specific things. First off, Lily's family has requested that we require 48 hours of jail time after arrest for the first offense of a DUI within a 10-year period. Previously, this was simply an option, and a court could choose a fine or jail time. Second, this bill brings Kentucky in line with neighboring states by making a third offense a Class D felony rather than a misdemeanor. The sentence is now mandated to be between 1 and 5 years as well. Previously, a court could choose a fine and jail time of no less than 30 days or more than a year. If there was aggravating factors, the 30 days became a mandatory 60. And so with this also, there is a House Committee title amendment declaring an emergency just for the committee's knowledge. And I will actually go ahead and pass it over to Speaker Osborne if he has any additional comments.
Thank you, Samaras. Thank you, Zoe. Couple things that are still in process on this bill. And we're obviously limited by time remaining in session, so we wanted to get this thing moving. That's why we chose to use a vehicle that was already in play, and also some ongoing discussions about the mandatory holdover time. Again, as Samara said, 48 hours was the request. I've already had a number of you that have expressed some concerns about that 48-hour time period, and certainly that is something for discussion. I think that we can all agree that that a minimum time long enough to sober up is appropriate, and it will be. I think you will find a complete openness and receptiveness to making sure that we are reasonable in that process. Another thing that Representative Nemes has been working on this is the requirement of the use of NCIC records, which I'm going to let him speak to that. I know he has been in touch with the chief and the Chief Justice as well as AOC about it.
Thank you, Speaker. Thank you, Mr. Chairman. The NCIC portion, which is not in the bill, I want you to know why it's not right now. When someone gets arrested, what happens is they go to jail, and the pretrial officer runs the CourtNet report, so that lets us know what their record is in Kentucky. They also run an NCIC report. They're supposed to run an NCIC report to let us know, let the judge know, or let the pretrial officer know when they make the recommendation to the judge whether there's any offenses outside of Kentucky. We know we believe that NCIC report is not being done each time. As I talk to the courts, I'm told that they're supposed to do that every time. We're figuring out exactly, what we can do to be helpful to make sure that's done, so our judges have all the information they need to keep the dangerous people in jail, and the ones that aren't dangerous, let the judge take that into account and the determination of when to release them or whether to release them. So we don't have the NCIC portion of it in the bill right now. We are working on that, and if we don't get that done this session, it's something that we'll be looking into in the interim. I'm informed by the court system that they're obviously dedicated to making sure that their pretrial officers do those reports and provide that necessary information to the judges.
All right, we did have one person sign up to give a couple of comments. Philip Lawson, if you could come up to the table and we'll make room for you.
Thank you. Cool. Thank you, sir.
Am I getting up too? Am I getting stay? Okay.
Mr. Lawson, you may identify yourself and proceed.
Yes. Good morning, everybody. My name is Philip Lawson. I'm the new legislative agent for KCDL. I know I haven't had a chance to meet many of you, nor have a chance to, obviously make a statement here. And, when I got the committee substitute last night, obviously hearing the testimony today, and like many of you, I also read the Herald Leader article from March 7th of this year regarding the drastic increase in fatalities here in the state of Kentucky that was released in 1920. So let me just start off my brief comments by saying I completely understand committee wanting to respond and review DUI laws in response to that. Not contesting that whatsoever. My concern, as well as ours in terms of the organization, is the DUI structure that we have in place has been in place since 1984. And it shows, and it's been designed to gradually escalate, first, second, third, and fourth. So my concern is that obviously, there's a desire to make some changes to address this. My concern is that I would just hope that, maybe we can, step back and maybe pause a little bit to make sure that a change such as this, which is, going from a 4 offense to felony escalation to 3, to make sure that it actually does address public safety. But secondly, I think that I'd like to bring to the committee's attention is that same article I read from the Herald Leader. I think it was March 7th of 2022 this year. Those statistics were from 19 and 20. Now, the important change between those and what we're experiencing under current law now is the implementation of the ignition interlock device system. Our DUI laws changed drastically when it came to the license suspension component when we enacted those changes where it made the ignition interlock device mandatory. I think from a large standpoint that has been very receptive in district courts. I'm not a lobbyist, as I've tell people. I'm a trial attorney. I'm a full-time criminal defense lawyer. Do some other areas, so I do some of this work, and it seems to be very receptive both from judges, prosecutors, as well as the defense bar. And my concern is that we haven't had enough time to see how that has impacted in terms of public safety. So again, I respect the committee wanting to address this issue. I just wanted to kind of raise those 2 points to say, let's think on this and make sure that we're taking a scalpel as opposed to, maybe a little bit more broad approach to this.
Thank you, sir. As always, legislation is a process, and we're at the beginning of that process. I think the speaker has already indicated, along with Representative Nemes, that there are some things they're working on even as we move forward in the process. But due to the late hour, so to speak, we needed to get it moving. And so we'll continue to work on that as we move forward. But with that, we do have a couple of questions. Representative Scott.
Thank you, Chairman. My concern is that we already have ridiculous overcrowding in the jail in Louisville, and the jail is used as a detox facility. And I know from my mother's own struggle with addiction that is inappropriate. What else can we do besides locking people up? Because that's not going to work, even for 48 hours. It seems like if we're using our jails as detox facilities, we're actually not addressing the problem, and people are going to get back out and have the same behavior. So is there something else that we could do besides arresting people?
Representative Nemes.
Thank you. I think that's a good question, Representative Scott, especially in Jefferson County where we've had 7 deaths in the last, 4 months. That's a very significant problem that we have to get our hands around in Louisville. I would note that this is a bill that applies to all 120 counties, and not everybody has the same problems that we have that we need to fix. But I would say this: the 48-hour rule that we're working on, as the speaker suggested, it's not time to treat the person then. It's time to protect the community. Let's not let them get back out. And I know we have overcrowding. I get it. We have to address that, no doubt. But this person is a danger to themselves and to others. They were recently, within the last few hours, in front of a steering wheel driving a car. So we need to get them off the roads immediately. That's what the 48-hour hold does. And I would suggest on the third term, that making the third offense a felony. My friend mentioned the interlock device. That's why it's even more reasonable that we make that change, because if they're getting to a third offense after we've already done those things, including our new interlock interventions, that's even worse. And this is within 10 years, they have a problem. What this does is it mandates 240 days on the third offense. And so we need to do more treatment, yes, but I think these 2 provisions are necessary at this time.
Representative Mosier.
Thank you, Mr. Chair, and thank you for bringing this legislation. I think it's really important that we continue talking about this. And Zoe, I'm so sorry for your loss. How tragic. And no family should have to go through what your family is going through now. I completely agree. I agree that when an individual is, especially if they're on their third DUI, and they're picked up yet again, that they should have a 48-hour hold to make sure that they are safe and no longer a danger to others. We already have a 202A statute. I'm wondering, that's 72 hours. I don't know if you've considered that provision in looking at this legislation. I know that this is a process, so maybe we can talk about that. And also a mandatory assessment. And that would speak to Representative Scott's issue with the whole idea of, the individuals not getting help for their obvious issue with alcohol. So I think that probably a mandatory assessment during that 48 hours would be prudent. So have you considered anything like that?
Chairman Moser, I didn't. Obviously, I have not brought Representative Nemes along for his good looks.
Watch it.
The reason that Jason is involved is because he deals in a lot of these matters and has kind of evaluated that and feels like this is appropriate. Had not talked about the mandatory evaluation though. However, so I will yield to his thoughts on that.
There are when somebody gets arrested. It doesn't happen every time and in every community. It certainly happens in Louisville most of the time. When someone comes in, there's a nurse right there. So if you go into the jail, you go to the holding area, then you go to the pretrial officer, which is sitting up there. Sometimes it's on the phone, but most of the times in Louisville, it's a bench. It's not a judicial bench, and there's a nurse right next to it. And sometimes they can get treatment. It's not every time. I would say this is much different than 202A because 202A is obviously by definition a danger to themselves or to the community. These people in the short term are a danger to the community. They've already shown that because they were recently in a car inebriated. But we need to distinguish between social drink. All of it's wrong. They put themselves and the community in significant danger. No reservations on that. But someone who's a perennial offender or someone who's multiple times is different. And so perhaps bottom line is we need to talk more about treatment. Obviously, this bill doesn't do that. It doesn't increase that or decrease that aspect.
Representative Elliott.
Thank you, Mr. Chairman, Mr. Speaker, and Representative Heverin and Representative Nemus. Thank you for working on this issue. You know, my great aunt lost her husband in the 1960s. In her 30s, he was killed by a drunk driver, and she remained a widow up until her death about 20 years ago. So my family has been touched by this issue as well, and so I thank you for your bravery, Zoe, in appearing before our committee today. Is this typical of most states in the country to require a hold of 48 hours? Is this new ground that we're breaking here, or is this something that other states are doing?
We're looking at that. Most states have a hold. We don't necessarily have a hold in Kentucky. It's an or in the statute here, and a lot of times what's happening is people are getting released before they're sobered up, and at the very least, the Kentucky law should say they don't get out till they're sobered up. And so I'm looking at that right now. We're looking at it very quickly. Most states have a hold. I can't tell you what 30 states have versus 20 states on the hours. Looking at that right now, and I would also note that the other change we're making on the third offense is my understanding the majority of the states have the third offense whereas we have the fourth offense.
Thank you. It's good to see Phil, too. We were old law school classmates, so it's good to see you here as well. Thank you, Mr. Chairman.
Representative Decker.
Thank you, Mr. Chairman, and thank you so much, Representative Heverin, for bringing this bill. And Zoe, my thoughts are with you. My family, too, was impacted by drunk driving. In 1962, I was sled riding with my brother down a hill into an alleyway that was blocked off on both ends with barricades. A drunk driver knocked down the barricade, drove in, and hit my brother in the head. Praise God he lived after brain surgery, replacing every bone in his ear. So I appreciate the fact that this is Lily's law. I'm thankful it's not my brother's law. He lived. But I have a few questions, or comments actually, in response to the questions about the 48-hour rule. I do think our jails are overcrowded. I do think that's a problem, but this is a safety measure. Perhaps my brother would not have been hit in the head by a car if they had held that drunk driver. I am curious, though, about the committee sub and why it left out the provision about taking of the driver's license.
License plate.
Oh, I'm sorry, the license plate.
That was actually rolled into another bill. It was Representative Flannery's House Bill 154. It was rolled into his bill. So this is already taken care of. It's passed. It's in the Senate. I believe it might have even passed on the consent calendar yesterday in the Senate.
Thank you.
So the license plate issue has been taken care of already.
Thank you. And again, thank you for bringing this. I do think treatment is a major issue, and I hope that can be addressed as well on these repeat offenders. Thank you.
Representative Cantrell.
Thank you, Mr. Chair. I think since we're all telling our stories here, I've also been impacted by drunk driving. Luckily, it was only my property that was damaged. A drunk driver flew through my apartment complex and hit my car. Luckily, I think I was asleep when it happened, and I can't imagine, the if I had been physically injured, and people who have been physically injured who have been impacted by this. It's terrible, but I think that all of us having a connection and story about this shows what a common offense this is, and we know that this is a commonly charged offense. And I haven't looked at this in a while, but I know that the data shows, for the most part, after your first DUI offense, a lot of people do not commit a second offense. So if we're going to hold somebody in for 48 hours, we know that they're going to get out. We know that they're going to move on with their life. You know, a lot of collateral consequences can happen when someone's left incarcerated. If they were supposed to be at their job a day or two later, say if they get picked up on a Saturday night, they were supposed to be at their job Monday morning, they don't show up, they lose their job, and they can't even, you know, if they were in an accident that caused that DUI offense that Saturday night, they're not even going to be able to account for the financial impact of their actions if they don't have, you know, any economic security to pay for restitution, for example. And I keep thinking about this, wondering if there's a better way. Maybe if we could start at 12 hours and maybe have some sort of data, like we know that we have breathalyzers. And if the idea is until when somebody is sobered up enough to be released, if we could use something like a breathalyzer to prove that they can meet certain criteria and lessen the impact of those collateral consequences. This bill just needs a lot of work, and I'm willing to continue this conversation, but it still needs so much work.
Representative McCoy.
Mr. Chairman, real quickly, if I could, just very quickly. My friend is correct on most people don't recommit the same offense, but 1 in 5 do. And we also know that you don't get arrested and caught every time you drive drunk. And so, you know, I want to put that up for consideration as well.
And to follow up with Representative Nemus, in our meeting earlier this week, we were talking with the Fairfields, and generally someone will drive 80 times before they get caught in their first DUI, and I think that's very eye-opening, and it's something that members of the committee should really think about too.
Thank you, Representative McCoy.
Thank you, Mr. Chairman. I have one question and then possibly a comment, depending on the answer. Am I hearing you all say that in the committee sub there's a mandatory 48-hour hold post-arrest? Because the section I'm seeing is actually the what happens after you're convicted. And there's a distinction there, and I'm just trying to make sure I understand.
So the intent is, I think we're talking about on page 3, Representative McCoy, the intent is that there be up to a 48-hour hold upon arrest. And if that's not clearly what the impact is, that's the intent. And again, we're working on the exact language on 48 hours, so I'll talk with you.
Yeah, because this is actually, I have done a lot of DUI law. This is the section on the punishment for after you're found guilty. But so now my comment with respect to the 48-hour hold, and Zoe, I appreciate what you're doing. I love to see somebody trying to change it, you know, rather than just accepting it. But as someone who's done a lot of DUI law, not every DUI arrest is the same. And no offense to Representative Blanton, every now and then the cops don't get it right, and the criminal lawyers get it kicked out. And I don't know of any other crime, and maybe you guys can tell me, where there's an automatic deprivation of liberty and arrest and jail time simply because of an arrest. That seems to me that would violate the Constitution. So anyhow, a lot of work to do there. Nemus, just one quick question for you, or a comment. On the NCIC part, will you make sure that as that goes through development, it becomes part of the discovery for the criminal file?
I would like that. I think the Court of Justice would have an objection to that, but we'll work through those issues.
I would think, though, if it's going to be evidence that holds a defendant in jail, I would be entitled to see the sufficiency of that. You know what I mean? So fight for it. I'll help you. Thanks.
Representative Massey, may I make a quick comment to that? Yeah, thank you. Like you, Representative McCoy, I'm a criminal defense lawyer. I've been doing it for 10 years, used to be a public defender. Just to comment on your two statements, I agree with your reading that it doesn't have the 48-hour hold. And then secondly, I am also unaware of any law in our state that would require 48 hours upon arrest.
Representative Blanton.
A few quick comments, Mr. Chairman, very quickly. First, I'm reading this the same as Representative McCoy. This looks like a conviction. Maybe it's not in the right place in statute of what you're trying to accomplish for the hold. Secondly, and it's been a few years since I've arrested somebody. When we're saying we don't hold anybody, last time that I arrested somebody on AI, it was 4 hours minimum before somebody could sign them out. 8 hours then before they could sign themselves out. So putting some hours hold on initial arrest is not new in Kentucky. We already have that under just simple alcohol intoxication. That exists. Tennessee, my understanding, already has a 48-hour hold on DUIs initially, and we can debate the amount of hours it needs to be. That's one thing, and I have experience where I have arrested someone, taken them in, administered intoxilizer. They were well above the legal limit, and before I got my paperwork processed, they were released. I've had that happen multiple times to me. So that person could potentially go right back out, get in a vehicle, drive down the road, hit and kill somebody. Now, I don't know how many of y'all have had to help remove the bodies out of vehicles of someone who's mangled. Things that images that never leave your head, you carry with them. And then when you go to that car and that body you're removing is an infant over something that was preventable. We're sitting here debating on rights. This world has forgotten victims. That mother or father or that child deserved to die because somebody, and Representative Nemus is exactly right, the odds of somebody getting caught driving intoxicated is pretty slim. And if you're getting caught multiple times, you've got a problem. Now, I will point out that there is legislation, if you go over in Section 10 or 2, that does require treatment as part of your agreement in your plea to be enrolled in alcohol abuse treatment in Section 2. That's already in statute. So I get it. We want to look out for people's rights. We want to look out for people's jobs. But when in this country do we forget about victims? You see, that victim will never be able to make another dollar that's dead. That child will never be able to have a life. Until you have those images seared in your brain because something that could be preventable, this is a good thing. We need this. We should have already had this. Thank you, Mr. Chairman.
And last question, Representative Bratcher.
Well, if somebody is on their third DUI and part of the DUI was that they killed someone in another car wreck, how long would they, what is that a felon? Would that be a felony?
Currently,
if they were convicted?
You talking about currently, Representative Bratcher?
Yes.
Well, if they wouldn't be a DUI, it wouldn't be a felony for the DUI. They'd likely get charged with wanton endangerment or something else that is a felony. That's my understanding. But the third offense DUI, if they kill somebody, in and of itself is not a felony, but they'd probably be charged with other things as well. You want to speak to that, Phil?
Yes. Representative Bratcher, I actually brought a DUI guilty plea form just to kind of help remind me of the aggravating circumstances. Yes, if somebody were to be seriously physically injured on a DUI third offense, as it sits now, it would be an aggravated circumstance under the DUI third. But he would also, this person under this hypothetical, would likely be charged with either reckless homicide, manslaughter, or something even worse. I've had cases involving those types of things. So even though the DUI would not, under our current law, be considered a felony, it'd be an aggravated Class A misdemeanor with, I believe, a punishment up to 12 months. There are obviously other crimes that could be charged alongside that.
All right, thank you.
And those aggravators are listed on page 6.
All right, so we've had this presentation. I need a motion to adopt 185 as amended by the committee substitute. A motion by Representative Blanton, the second. second by Representative McCoy. All right. Madam Secretary, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes, and thank you, Zoe, for coming up and help presenting. Yes.
Representative Cantrell,
May I explain, please? I'm going to vote yes because I trust you all to address what has been said today, because there's clearly a lot of issues that need to be resolved. I'm a little bit uncomfortable doing this because I'm very much voting for an idea, and an idea that is not expressed on the pages that we have been given. But I do expect you all to work on this quite a bit if you want to get it done this session, and continue to see how this idea gets turned into actual policy, because I don't think we're quite there yet.
Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Yes.
Representative Heverin,
Yes, and quickly explain my vote. I'm voting yes today for Lily and for Zoe here with me today. I just really want to brag on Zoe for her courage, and this is a big conversation. The Fairfields are constituents of Speaker Osborne, and so here the Fairfields have brought this issue, and they've seen their representative bring this into policy, into legislation, to see the conversation, and so I think that's really the true. Zoe gets to be part of that conversation of seeing how laws are made, and she's advocating something terrible happened. She's having the courage to advocate and make better so this doesn't happen to anyone else in the Commonwealth. And so I vote yes today for her bravery and her family for advocating.
Representative Cole Carney,
Briefly explain. I'm going to pass for today. I appreciate the sponsor's intent and them bringing the bill. And Zoe, thank you so much for your engagement. I do echo some of the concerns that have been brought up by my colleagues today. And just for clarification, I did have a question, but we can get to that later, that this is establishing a minimum holding time of 48 hours up to 30 days. And so that's a concern. But I'm going to pass today in the hopes that you all are going to work together to get some of these issues addressed. And I'll certainly be following up with the sponsors as well with those. Thank you.
Representative Lewis,
Yes.
Representative Maddox,
Pass.
Representative McCoy,
Yes.
Representative Minter,
Briefly explain. Zoe, thank you for your advocacy and your courage, and I'm so sorry for your loss. I'm voting yes today, but I concur with Representative Cantrell that this is still a concept, and there's a lot of work to get it across the finish line. But I'm certain that work will be done based on the good conversation we've had in committee today, and that's the purpose. Thank you.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Scott,
Chairman, I'm going to pass. I know that you all are going to be working on it, but when I'm talking about treatment, I'm talking about getting treatment before sentencing, when you get arrested, being sent to treatment. So I'm passing today.
Representative Stevenson,
I am passing today. There's a lot of work that needs to be done on the bill, so there are no unintended consequences, and the right people get held for the right purpose.
Chairman Massey.
Yes. 15. There being 15 yes votes, 0 no votes, and 4 passes, the same will be reported with favorable expression that the same shall pass. And you had 3 passes? I had 4. Okay. There's also a title amendment to this, so I need a motion. Representative Blanton, is there a second? Representative Mosier? All in favor signify by saying aye. Aye. Opposed? There's none. All right. Congratulations, and thank you for your presentation. Mr. Speaker, while you're here, we're going to go ahead and call House Bill 675. Is Representative McCoy still here? Okay, great. I can't either.
Mr. Chairman, I'm going to step out for just a second.
That's fine.
I have to take a quick
we,
phone call.
We have several other matters
I
we
know
can
you do,
call
and
up.
I appreciate
so
your indulgence.
Thank you, Mr. Speaker. All right, then we'll call House Bill 216. Representative Lawrence. Okay.
Can we do 217, Chairman?
That'll be fine. We have 216 and 217. So
My guest speaker has got to go to court at 1.
okay, that's fine. Then we'll do 217.
Okay. Yeah, he's there. All right. Thank you, Chairman. Thank you, members of the committee. My name is William Lawrence. I am the state representative for the 70th District, and I have with me today Jeff Schumacher, an attorney from my district. If you'll introduce yourself.
Good morning, or good afternoon, rather.
I want to first say thank you to the chairman and Representative Mosier for your help on helping draft this bill. I'm going to let Jeff, if you would, just kind of explain the bill briefly. I know we've got a very full agenda today, and we'll move forward.
Very quickly, when I practiced for 30 years in Kentucky courts, and numerous times have I done termination of parental rights cases, typically for young women who have fathers that are not involved with the child, don't know the child. And so I would routinely do these cases because these women did not want, if something happened to them, for that uninvolved other parent to come in and take the child. They wanted to be able to terminate those rights, and then by their own last will and testament, able to determine who received custody of that child. So I did those typically, in 30 years, I've done numerous of them. And so I filed one a couple of years, or maybe a year and a half ago, and it was rejected because there had been a recent change in the statute, and the statute basically said if you had never had, you could file it for a termination. A parent could still file, but if you had never been involved with a cabinet case before, that you couldn't get a final resolution. Whereas, which made no sense because a good parent that had never had any involvement with the cabinet was being prevented from terminating a deadbeat parent, whereas a person that had been involved with the cabinet and had a lot of cases in the cabinet, which would indicate they had their own issues, they could do that, but it didn't make any sense. And so we tried to get it through, and my circuit judge said, well, the law's got this conflict. I'm not going to rule on it. I'm not going to allow it. I then filed an appeal with the Court of Appeals. The Court of Appeals came back with the same thing, said this is a legislative problem. They've created this conflict. And I talked to Representative Lawrence, that was very receptive, and we talked to the other committee members at the time that work on the drafting of these legislation, and we came up with a draft that fixes the problem very easily and allows those kind of cases to go forward, regardless of whether they've had cabinet involvement or not. And that, in a nutshell, was I got involved.
Motion on the bill.
We have a motion on the bill by Representative Nemes. Do we have a second? Representative Mosier? Do we have any questions? Seeing none, Madam Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Cantrell. Representative Decker.
Yes.
Representative Elliott.
Aye.
Representative Fisher.
Yes.
Representative Hebron. Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative McCoy.
Yes.
Representative Minter.
Yes.
Representative Mosier.
Yes.
Representative Nemes.
Yes.
Representative Petrie.
Yes.
Representative Scott.
Yes.
Representative Stevenson. Chairman Massey.
Yes. They're
That's how you
being
do it.
Can I please record a yes vote? I
absolutely.
think I missed my name.
That means
Been a
there's
long day.
19 yes votes, 0 no votes, and 0 pass. The same will be reported with favorable expression that the same should pass. Thank you, and you may remain seated for House Bill 216.
Thank you, Jeff.
Thank you all very much. Go to court now.
All right, we already know who you are, so you can proceed.
Well, that was easy enough. Christy, I will let you introduce yourself. Just introduce yourself to the committee, if you would, please.
Sure. My name is Christy Birch. I'm the CEO of the ION Center for Violence Prevention. We serve domestic violence victims and sexual violence victims in 13 counties in northern Kentucky and Buffalo Trace.
Thank you, Christy. The bill that I have brought you today, House Bill 217, will add the domestic violence shelters as a covered location for terroristic threatening. Christy, could you give them a quick background of the story that you had brought to me and why this is so important to your center and other domestic violence centers throughout the state of Kentucky?
Absolutely. Thank you all. Thank you, Chairman Massey, and thank you, committee. In September of 2021, a person fled to our Maysville program. Her partner was being extremely physically and mentally abusive. After about 10 days with us, her partner began texting her nonstop. He called our hotline over 40 times in 2 days. He actually pretended to be a Boone County police officer. He'd cuss and scream at staff who answered. He made threats toward the Ion Center and the client. He demanded that we let him talk with the client, even though he didn't know if she was there or not. If we didn't get the client to respond in a certain time frame, he threatened to hurt her and us. He called her in one day over 100 times from multiple numbers. He used burner phones, burner apps, just so we couldn't trace him. He called her place of employment and was stalking her there. Maysville Police Department, in fact, had to walk her to her car as she closed at night at her job. On 9/18, he texted the client and stated he had a 9mm, and he and a friend were on their way to light the place up. He gave her an hour to call him back. He also then called the Ion Center and told us he was on the AA coming to get us. And as I listened to the recording, he said, "You have 15 minutes to get her to call me or I'm going to blow this place up. It's going to be a big finish. You're going to watch this shelter go boom." We're so grateful to the Maysville PD. They were right there. And in fact, they did ping his phone and he was on the way on the AA. And for us, the reality set in that these threats could be carried out. We made an evacuation strategy with our fire department and police were stationed outside our shelter. He was arrested, and when he was charged with terroristic threatening, he could only be charged with a misdemeanor because shelters were not schools or government entities. You all know very much that a safe place for survivors to escape is foundational to shelters. Staff were also tremendously impacted by these threats. They already have profoundly difficult jobs supporting children and people through the worst of their sufferings. Our staff and shelter provides these life-saving services, and we know the most dangerous time for survivors is when they make the decision to leave. Research tells us 45% of DV homicides are triggered when survivors leave. And we also know that 20% of victims of domestic violence related murders are not survivors. They're corollary victims. They're friends, family, neighbors, police officers, bystanders, shelter staff. In the late 1990s, myself, as an advocate then at Sanctuary in Western Kentucky, I drove up as a perpetrator fled the scene after shooting my client 5 times outside our outreach office and holding a gun to my colleague's stomach.
Motion on the bill.
We have a motion on the bill by Representative Nemes and a second by Representative McCoy. Ma'am, typically when things are going well, we stop talking, so we're going to see if there's questions. And we do have one question that Representative Cantrell.
Thank you, Mr. Chair. I'm trying to do some quick research over here. It looks like terroristic threatening comes in the 1st degree, 2nd degree, and 3rd degree. The 2nd degree is a Class D felony. I'm trying to look at some of the definitions, and then in the 1st degree, this would be a Class C felony. And obviously, the situation that was described in this example is obviously between the constant calls, impersonating a police officer, threatening the entire safety of that structure. Obviously, falls within that, and I think a Class C would be appropriate. Are we missing something in not putting this also in the 2nd degree terroristic threatening statute?
Christy, would you like to respond to that?
I think it's something that we can look into. I would probably, possibly. So I think that, again, these are such critical issues, and severity of violence is extreme. We've seen so many homicides recently of domestic violence victims. So we definitely need as much protection as we can possibly have.
And I would like to quickly say that the Women's Crisis Center, or the Ion Center, recently just changed their name in our district. These domestic violence centers are probably one of the places that's going to be the most susceptible to people coming there to attack them, because that's where their partner has went to hide from that individual that's after them. So definitely want to do everything that we can to protect them and that facilities.
All right. Seeing no further questions, Madam Secretary, please call the roll.
Representative Banta?
Yes.
Representative Blanton?
Aye.
Representative Bratcher?
Yes.
Representative Cantrell? Yes. Representative Decker?
Yes.
Representative Elliott? Representative Fisher?
Yes.
Representative Heverin?
Yes.
Representative Cole Carney?
Yes.
Representative Lewis?
Yes.
Representative Maddox?
Yes.
Representative McCoy?
Yes.
Representative Minter?
Yes.
Representative Mosier?
Explain my vote quickly. I want to thank you for bringing this very important piece of legislation. I am a yes, definite yes, enthusiastic yes, and two excellent bills today. Thank you.
Representative Nemes?
Yes.
Representative Petrie? Representative Scott?
Yes.
Representative Stevenson? Chairman Massey?
Yes, there being 18 yes votes, 0 no votes, and 0 pass, the same will be afforded with favorable expression. The same shall pass on the House floor. Thank you.
Thank you, Chairman and members of the committee. Thank you, Christy.
Thank you all so much.
Now that we have Representative McCoy back, we'll call 675, House Bill 675.
Motion on the sub.
Motion on the sub by Representative McCoy, second by Representative Nemes. All in favor signify by saying aye.
Aye.
Aye. Opposed? All right. There's none. You may proceed.
Thank you, Mr. Chairman. Ladies and gentlemen, this is a bill that we did last week, and last week, trying to be efficient, we added another bill onto it, and Representative Daniel Elliott, along with Representative Nemes, had some concerns. That bill is still being worked on. It was one sponsored by Representative Minter, and I think they're going to continue to work on it. So what the committee sub does is it undoes all the efficiency we did last week, pulls that bill out, and is running just the one that the portion I spoke about last week, which was something for the speaker. This is the Jeff Tyler Act. It deals with the very limited situation of a limited guardian or a limited conservator. Just clarifies that a court can appoint somebody in an emergency before we get into the whole hearing. It also clarifies who can bring the petition, and that the petition has to be accepted by the clerks so that it can all go forward.
Second.
We have a motion on the bill by Representative Blanton. We have a second by, I believe, Representative Nemes. Okay. All right. Any questions? Seeing none, Madam Secretary, please call the roll.
Representative Banta?
Yes.
Representative Blanton?
Aye.
Representative Bratcher?
Yes.
Representative Cantrell? Representative Decker?
Yes.
Representative Elliott? Representative Fisher?
Yes.
Representative Heverin?
Yes.
Representative Cole Carney?
Yes.
Representative Lewis?
Yes.
Representative Maddox?
Yes.
Representative McCoy?
Yes.
Representative Minter?
Briefly explain my vote. I'm a yes today, and I'm glad to see 675 moving forward. It does some things that are extremely necessary, and I'm glad Representative McCoy noted that we'll continue to work on the CARE Act part of this, because it also does things that are extremely necessary. Look forward to working with all of the stakeholders to move that bill forward. Thank you.
Representative Mosier?
Yes.
Representative Nemes?
Yes.
Representative Petrie?
Yes.
Representative Scott?
Yes.
Representative Stevenson? Chairman Massey?
Yes, there being 18 yes votes, 0 no votes, 19 yes votes, 0 no votes, and 0 pass. The same will be reported that House Bill 675, as amended by the committee substitute, shall pass favorably on the House floor. Thank you. All right, just bear with me for a moment because I'm going to have to move down to the podium and transfer the gavel over to the Vice Chair, Representative Banta. I'm just going to put them in order for her so that she can get these called quickly. We're going to do
Motion on the committee sub.
Which bill? Which one?
782.
Okay, thank you.
Have a motion from Representative Nemes and a second from Representative Fisher. Voice vote to adopt committee sub. All in favor say aye. So moved. Oh, I'm sorry. Any noes? Say no. Thank you. You may proceed.
Thank you. I'm Ed Massey from District 66 in Boone County, and I have much better looking presenters with me. I'll let them identify themselves.
I'm Stacy Tapke, the Kenton County Attorney and President of the Kentucky County Attorneys Association.
And Sarah Beth Gregory, the Chief of Staff for the Auditor of Public Accounts.
Actually, this is an act relating to county attorneys, and because we have those folks here today, I'm going to let them present it, and then we'll take any questions.
I'm actually going to defer to the Auditor's Office, who prepared some remarks this morning, and we'll be happy to answer any questions and appreciate their collaboration with county attorneys.
Thank you, Stacy, for assuming I prepared remarks. No, thank you, Mr. Chairman and members. It's a pleasure to be here on House Bill 782 and this committee substitute, which truly is a collaborative effort between the Auditor's Office and the Kentucky County Attorneys Association. Really want to commend Stacy and their leadership for working with us on this. As you may be aware, a couple of years ago, our office conducted a special examination and looked at several county attorneys' offices and made a number of observations of areas where we thought there was room for clarification that could be beneficial, both from a public transparency standpoint and beneficial to county attorneys as well. So this bill seeks to address several of those items. Number one, it clarifies end-of-term transfer of office protocol. That's been an issue in a number of counties where successors have been elected and had some issues with getting the resources of the office transferred to them. It also notably would create an annual financial reporting element for county attorneys to file some financial reporting with PAC. We did set that out a little bit to start that, so there's plenty of time for everyone to be trained and understand what the expectations are, but we think that's really a positive step forward for county attorneys who don't currently have to do that. And it would also amend a statute that allows county attorneys to invest funds, just like other county officials. There's an investment statute that listed pretty much every county official, except for some reason, county attorneys. And so we think, that's a good clarification as well. And then the final clarification or change that it makes relates to cold check fees, which is one of the many functions that county attorneys handle, is assisting with collection of cold checks. And it would simply treat those fees consistent with every other fee that comes into the county attorney's office. It would be restricted to use by the county attorney's office for operating purposes only.
We have a motion on the bill from Representative McCoy, a second from Representative Heverin. Do I see any questions? I have a question from Representative Scott.
Thank you so much, Chairwoman. Just one question, wanting to understand the reasoning on page 11 at the bottom for taking out the point about the excess fees. I just want to understand the purpose.
So that relates to what I said, making it consistent with how they handle all of the other funds that come into their office. The cold check fees, from what I understand, and Stacy could speak more to this, but it's a very minimal revenue stream. It's really a declining revenue stream for most county attorneys who are even still handling it at all. So it's very rare for those fees to be turned over as excess fees, and to the extent that there are any excess fees, it's very minimal. One of the things we noticed when we did our special exam was there are even a few counties who had passed an ordinance to say, we don't want you to turn these over, county attorney's office, you keep them and retain them for your operating purposes. So we just thought moving forward and trying to give clarity to all of our county attorneys, it would make sense to treat all of their revenue streams the same and not have this one tiny little funding stream that's handled differently.
Okay, so you had mentioned cold check fees earlier. That's the same
That's
as
what that is.
excess. Okay, thank you. Thank you, Chairwoman.
No other questions? Please call roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes.
Representative Cantrell, Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Yes.
Representative Heverin,
Yes.
Representative Colcarney, Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative McCoy,
Yes.
Representative Minter,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Scott,
Yes.
Representative Stevenson, Chairman Massey.
Yes.
18 yeses. $18 yeses, no pass, no noes. should pass on the floor. You may introduce your next bill.
Ed Massey, District 66, Boone County. The next bill is for the Prosecutors Advisory Council. It's House Bill 773. And for all the members, this is almost a pair to the Judicial Council that's already passed this committee and is on the House floor.
Motion on the bill.
Motion on committee sub by Representative Nemus and Representative Blanton, second. And now I have a motion on the bill from Representative. All in favor of the sub, say aye. Aye. All opposed? Okay. Now we have a motion on the bill from Representative Fisher and a second from Representative Mosier. Do I see any questions? I do not. Let's call roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes.
Representative Cantrell, Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Yes.
Representative Hebron,
Yes.
Representative Cole Carney, Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative McCoy,
Yes.
Representative Minter,
Yes.
Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Scott,
Yes.
Representative Stevenson, Chairman Massey.
Yes.
With 18 yes votes, no passes. Expressions the same should pass on the floor. Please introduce your next bill.
This is the last one. This is an expungement bill. It's Senate Bill 33. And I do want to explain the history a little bit so people are clear of what's going on here. So Senate Bill 33 passed. It had a floor amendment that several thought was problematic, which we addressed. But we also, as part of this bill, brought in another bill that had been filed by Representative Huff. There are two distinctions because one deals with the core concepts of expungement. The other one deals with ability to pay fees if you can't afford an expungement. And that was the portion that was presented by Representative Huff. We've been working on this for a number of years now, the expungement piece, and we passed bills relating to this, and it's worked mostly effectively. But there are some circumstances that some people just cannot afford to get the fees or the funds necessary, and certainly can't afford to hire an attorney to get these matters passed. And so that part of the bill addresses that.
We have a motion on sub from Representative McCoy and a second from Representative Nemus. All in favor, say aye. Aye. All opposed? Okay, please proceed.
So the work that was done on the primary piece of the bill, which is the Senate Bill 33, was to deal with the expungement and some issues that continually come to our attention. One of those is there's a difference in expunging misdemeanors and a difference in expunging felonies. And you may remember that in the past, we passed a bill that allowed Class D felonies to be expunged 5 years after the end of the sentence or end of probation, whichever occurred. So it's essentially still a 10-year period to get an expungement because you have to serve your original sentence, which is 1 to 5, and then you have to wait 5 additional years after that in order to have that felony expunged. But we have many misdemeanors that some of them can become enhanceable. We heard about one today. So we passed a bill of, I think 3 years ago, maybe 4, that allows a DUI if you have a second offense within a 10-year period as opposed to a 5-year period. It's enhanceable, so it counts as a second offense. And if you have a third within that time, it's also enhanceable. And of course, we dealt with a third offense here today. So there are certain misdemeanors that can be enhanced if you get a subsequent offense. Part of the issue is all misdemeanors, obviously, is a time served of a year or less. So typically on a misdemeanor expungement, you still have a 5-year period after that in order to expunge it. We were trying or attempted to try to clean up that language. But what happened with the Senate floor amendment is they put it a 10-year period on for expungement, which made it conflicting because it would take you 10 years to get a misdemeanor expunged when you could get a felony expunged after 5. And so that's why we sought to correct that in the language that's been filed before this committee, to allow those expungements to continue forward, but not to create an inevitable conflict between the expungement of a felony and the expungement of a misdemeanor. And so that's why the language was changed to reflect that. The other thing that was talked about with the AOC is they were keeping all of these files for misdemeanors, and if it was going to be a 10-year period, they're going to have to keep all of these files for 10 years. And that created some problems. So we worked with them to get this language straightened out so that if it's not an enhanceable misdemeanor, that after 5 years, those files could be destroyed and a new offense would become a first offense for purposes of expungement. So I will be happy to answer questions about specific parts of the language.
Okay, I have a motion on the bill, including the committee sub from Representative Blanton. Do I have a second? I have a second from Representative McCoy. Any questions? Yes, Representative Nemus.
We're getting there, but expungement, when it's not enhanceable, should be immediate. It should be free, and it should be automatic. The court system should do it. It should not have to require a motion. It should be done automatic, and it should be free. When can we get there?
Well, actually, I would second that motion. I've talked with Representative Nemus about this. I believe if you've done the crime and you, so to speak, done the time, then you've paid your debt to society, and therefore you should have that lifted from you. We are working on it. It's taking a long progress to get there, but certainly it also helps our workforce. People don't think about that, but people that have records, it impacts their ability sometimes to get good paying jobs. And because of that, we're also continuing to work on this product. We will continue to work in that direction, Representative.
I want to thank you for that, Mr. Chairman, and also on your work for voter restoration, which is weaved together with this issue. You've done a lot on that, and so is the Senate sponsor, Senator Higdon. So I'll be a yes, and we're almost there. Thank you.
Any further questions, comments? No? Okay, please call roll.
Representative Banta,
Yes, briefly speak. I like this. We're going in the right direction, but I look forward to Representative Nemus's bill next year. Thank you.
Representative Blanton,
Aye.
Representative Bratcher, Representative Cantrell, Representative Decker,
Yes.
Representative Elliott, Representative Fisher,
Yes.
Representative Hebron,
Yes.
Representative Cole Carney,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative McCoy,
Yes.
Representative Minter,
Briefly explain my yes vote. Proud to vote yes for this great bill today. It's a big step in the right direction. I look forward to going all the way, hopefully in the next session. And it's also time to ban the box. Let's just take care of all of this. Thank you.
Representative Mosier,
Briefly explain. I am a yes today. This is a very good step in the right direction. I look forward to working with Representative Nemus on a clean slate piece of legislation. Thank you.
Representative Nemus,
Yes.
Representative Petrie,
Yes.
Representative Scott,
Yes.
Representative Stevenson, Chairman Massey.
Yes.
Okay, with 19 yeses, 0 nos, and 0 pass, with the expression it should be the same on the floor. Thank you very much. Congratulations.
Thank you. Before we adjourn, I think Representative Petrie didn't call out a vote on 217 or 16, one of those. I wanted to ask him, or let you ask him if he wants to record a vote.
Representative Petrie, you still there?
I am, and I heard that in 216. Yes, please.
Gotcha. Thank you.
Thank you.
Okay. Any
And
last-
Chair, I'm sorry, this is Nima Kulkarni, Representative Kulkarni. I'm so sorry. I think I missed the roll call on 770.
You did.
And I'd like to record a yes vote, please.
Okay. Thank you very much.
Thank you.
If nothing else, thank you very much. We are adjourned.